I'm Dr. Barry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. Lori Vallow Daybell, she had a status conference. And this is the first time where we're getting a look at how she might act as her own lawyer. The last video that I did covering this topic, we took a look at the judge asking her questions about is she first of all, was she competent for trial? And an evaluator determined that yes, she is competent for trial. And then she was asked questions about being able to represent herself. And yes, she is able to proceed and I got this via DM on Instagram, so thank you to the psych nerd that requested this. I already had it on my radar as soon as I saw the video. This video is only about 15 minutes long. I will be interrupting the video. If you would like to see it without interruptions, I always include links down in the description. I also just wanted to say happy Saturday. This is the first Saturday of the new year. I normally stream on Tuesdays and Saturdays. And randomly, sometimes we'll have a pop up live. But oh my gosh. Because the comments, I am here for all of this because somebody mentioned that she seemed to be almost wasting the court's time. But this is when someone represents themselves, they don't know the law. They are going to bring up motions that are irrelevant, and this can waste the court's time. But it is what it is. She has the right to represent herself, and we are going to move forward. And she did also claim that she studied to be able to do this. Uh, oh my gosh. We are also we're not quite snowed in, so our road I believe is clear. But we went to the grocery store yesterday. We are true Virginians. We got about I think 2 inches, but we got 12 inches last week. That still hasn't melted, and so it's 1:30 now. At 3 p.m., my kiddo and I are going sledding. Right after this. So all right, let's get into the video. If you know nothing about this case, I have an update down in the description. Let's go. Uh-oh. It's not playing for me. Let's see. Let's try again.
Yeah.
I did receive it yesterday, but I was hoping that I could put my response on the record today, my reply.
That's fine. Go ahead.
Ready?
Yeah.
Okay. Oh, get my glasses. Do you want me to stand, Your Honor, or can I just sit here?
You can sit there.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kyles versus Whitley, 514 U.S. The acid test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of a conspiracy in the 100,939 pages that have been turned over by the state. The state does not get to say, like they did in their last motion to us in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet in reality, not in theory.
Okay. So you can tell by her tone that she is not pleased with the state at all. And she feels that these charges are frivolous and that the state has not been able to prove their case. The judge is going to stay incredibly calm during this. And towards the end of the hearing, the pool camera is going to pan down to Lori's foot because and so it's just so I don't know her so I can't I can't say exactly what's happening with her. In general, sometimes shaking can indicate some nervousness. Some people just kind of shake out of habit, but oh my gosh, this is gonna be a long ride, and this is her response to the state, and this is she's going to take time. She is going to take the court's time. It reminded me of Sarah Boone, but more prepared than Sarah was actually because she is gonna cite some law a few times, and I think her, not because it's not her, the on-call counsel, I think her investigator, and there are lawyers that are they can't give her legal advice, but I think she does have support, more support. Yeah, her advisory council, exactly. I think they are, just answering her questions. And now they're not gonna give her a legal strategy. They're just not. But, oh my gosh, this is gonna be a lot.
A standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of
And that to me sounded like she was thinking there was some type of conspiracy by the state. And and it reminded me when Sarah Boone was talking about feeling like the whole investigation was flawed. They never considered anybody else. It was this is a lot. And we're only two minutes in. And the first few seconds was the judge talking.
conspiracy in hopes that what the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide sweeping.
And if you're confused, the judge is gonna clarify later, okay? So, but we're gonna stay because I 'cause I've already watched this full thing, so I know what she's talking about, but the first time I watched, I was just like, "What?" Because, I didn't pull up her motion. I'll have to check in Arizona if those things are public record like they were for Sarah Boone, but wow.
Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the Brady Law and the right to due process. This is why in 2020, the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today.
And so she's now asking for all evidence of a conspiracy, but she's already said the state has given her over I have to make myself big for this. The state has already given her over 100,000, according to her, 100,000 pages of evidence. And the judge is gonna make a really good point later. I I just this is gonna be long, okay, y'all? This is gonna be long.
I would also ask that they would pare down their witness list to these witnesses that will actually be testifying.
And I don't think the state has to do that. Not a lawyer. Remember, I'm a psychologist, not a lawyer. But depending on how many people they have on their witness list, I think in the Chad Daybell case, I think the prosecution, it might have been from what I think there were a lot of witnesses on the state's witness list. Um
testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it.
And this is what happens when you represent yourself. And the judge did not say that to her. Okay. The judge, Judge Kranek told Sarah Boone, ma'am, this is the process when you represent yourself. It it might take 7 days for you to get notice of something that was filed. It's not on the state to make this easy for her. Kathy, thank you for mentioning this because I thought so, that the state does not have to pare down their witness list. They can have, because who, if they don't include somebody on the witness list, they can't call them. And without knowing what her defense is, and she doesn't have to disclose what her defense is unless it's one that's legally protected, like insanity or self-defense. Defenses like that, you normally have to file motions if you're doing battered spouse or something like that. But oh my gosh, this was this was a lot. This was so much. We're I'm gonna make myself small. We're gonna keep going. Once it 3 minutes in.
Get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
What,
And so what I think she's doing, okay? So I think what Lori is trying to say is that prior to Arizona finding out about the other crimes she was charged with, they never suspected that there was Charles Vallow, that he was capital M'd. And but I don't think she's going about this the right way. I don't think I don't think she is. I just don't think she is. Oh my gosh. We are uh
what does anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is.
Have you
So
read the grand jury transcripts?
I have.
Okay.
so the judge made a great point. And I wanted the judge to say it before I did, just in case I didn't. I'm gonna save this question because at the end of this we can take a look for anybody that wants to stay on and talk about that it's called the Slender Man case. If we want to stay on and talk about that, we will. But oh my gosh. With this, in the grand jury, so a grand jury said there was enough evidence to proceed with these charges. And she's trying to say, well, I don't think there is. Well, it's not up to her to decide. Like, that's not how this process works. And I think she wants to know what exactly they have, but there's already the grand jury information and testimony. And oh my, oh my.
The grand jury's transcripts summarize what the state's evidence they intend to produce at trial.
I understand that.
Do we though?
So when you say you can't find anything, that is the summary in the grand jury transcripts.
Correct.
Okay. So I guess I don't understand how.
Her use of correct also reminded me of Sarah Boone a little, where it's like, okay, correct, but because she's agreeing with the judge, but she's disagreeing at at the same time. She's agreeing and disagreeing. And I miss that she was wearing a hair tie as a wedding band. I totally miss that. She uses like a cutesy voice, and she also puts her hair up in, like, she looks childlike to me. I don't know. And it's okay for people to wear pigtails, to do those things. We just comment on things. Kathy, thank you for being a member for 3 months. So somebody mentioned this in the chat. I'll make everything big again, and y'all can try to see if y'all can see her hands to see the hair tie on it. All right, let's keep going. Oy vey. Ooh, and then Bama Green Eyes for 2 months. Welcome, welcome.
How an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
I can, Your Honor. There's the detectives that are on the
So I think I'm gonna make myself big for this again. When she's asked questions that I think she's not confident about, she starts to fidget with the stuff in front of her. So if you notice when the judge asked her that, she moved the book out of the way a little bit. I'll rewind it so that we can see this again. But the judge is gonna ask her that question, and then she's going to organize, like, she's gonna move the stuff in front of her. I can't say for sure that it's because she's looking for control. I can't say any of those things for sure, just in general. That's what I'm thinking. Um, so she was diagnosed. So I think in her sentencing video, so I don't have to suspect, she has been diagnosed with I believe, based on what I remember off the top of my head. Sometimes top of my head isn't great. Lori Vallow diagnosis, because she was assessed, and she was diagnosed with delusional disorder in the past, with spiritual themes. And then and I'm not saying that exactly the way the DSM, but I'm summarizing it. And then she was also diagnosed with narcissistic and histrionic personality features. And I do not disagree with any of that. I do not think her delusions caused her to do any of these things. My own personal thoughts, just based on what I've seen. Ooh, whoops, I meant to stay big. Based on what I've seen, a lot of her, I think her personality features are very strong. And after hearing her behavior from her cousin Megan, so there's an interview that Mormon Stories podcast, they did one, and then I think Hidden True Crime might have also interviewed Megan too, but a cousin of hers that had been roommates with her, that visited her family a lot, she gave history on Lori's dad and Lori's mom. And even though Lori grew up Mormon, it sounds like her parents were extremely lenient, almost to the point of permissive and possibly neglectful. And Lori was always trying to get attention. Always had to be the center of attention. She always had to be the prettiest. And there are some questions of, was there some anything inappropriate that happened to her? Once again, none trauma does not excuse behavior. It just kind of helps me understand. I would not be surprised if she had a history of childhood harm. That would not surprise me at all. And yes, yes, yes. All right. And it's my understanding that her dad raised them, that they were better than, I think that, like, they were in the top some percentage, let's say 10%, or but he raised them that they were superior, that they were the smartest, the prettiest, the best. That's how she was raised. All right. And I agree. I think the delusion was a lot of manipulation, because her delusions centered on what she wanted. It wasn't, because I've worked with people that have been delusional, and their delusions, they're saying, like, they did not want to think the way, but they kind of fell down a rabbit hole, and now they're believing these delusional things. Or but her delusions seem to correlate with things that would make her life easier or better. Like, it seemed to still center on her. She was still the narcissist, in my just personal thoughts and opinion, in her delusions. All right, let's keep it going. Wow. So I wound a little bit so that we could watch her behavior right here.
The detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people. Then I have
I think all these people work together, ma'am, because you lied and your crimes spanned states. You fled to Hawaii, but still, like your children were missing. Like that's why everyone collaborated. And now when you go back and watch Charles Vallow talking about she's I'm concerned about my kids, I'm concerned about my safety. She said that she's gonna unalive me. And then you have missing children, and then your lover has a dead wife, like all these things happen. We are going to look at you. Just don't do crimes. Don't do crimes. And Bama said you personally don't. I think you see her through because a lot of people talk about pretty privilege when it comes to her, and I've talked about pretty privilege. She can come off as like the doe-eyed victim, and she tries to, I think, use charm and manipulation to get people on her side. Those are just my personal thoughts. I think her lawyers are helping her, and that's what they're supposed to do. So, um, and I think she's doing things in a way that her lawyers probably didn't want to do. So her lawyers probably wouldn't focus on the extradition documents. Like I don't think her lawyers, because it really is irrelevant in my own personal thoughts, but I don't know. It's oy. All right, gonna make myself small. We will keep going.
um, them coming on, and they're going to be on the stand and they're going to be in trial and they're going to be saying what
She
they
almost makes it sound like they're gonna be on trial. Like they are testifying in your trial. Like they're not on trial. They haven't been accused of a crime. But I think she's gonna try to allege some type of conspiracy or something.
reviewed. They've reviewed all these things, and there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite. When I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory.
So is she mad that they brought her early? Like, ma'am, a press release and whatever the district attorney decides to do, so they can change their mind. Because let's say that's true. Let's say there was a news article where they said, yes, we're going to try to wait for the appeals to all go through before. Let's say that was true. But I don't know that it is, because I do think she lies. I think she does not tell the truth. And oh my, oh my. And in this moment, to me, she's not so paranoid that she seems to not be connected to reality. Her conspiracy is specifically for her case, and she just doesn't wanna be found guilty. I agree, Kaylee, that she is a prolific liar, and she will come up with a story. I just hope that the jury looks at the evidence, because I think she's good at BSing things, and that's a little scary, but we will keep going.
To that. I just don't know where it came from. And there's a lot of things that are mystery questions to the defense that we are entitled to according.
But I don't think she understands that she's wasting her time, because even if, let's say there is some evidence, because she wants their communications to figure out why they decided to press charges. I don't think that the defendant is entitled to that unless you're alleging like some fraud or something, and she's not using those words, unless you're alleging that something like somebody took a bribe, or like unless you're alleging a crime took place, they could change their mind.
Into the law.
All right, well, everything you've just told me, none of that would be relevant in the trial,
None of it.
in the case in chief. Does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime of that have been charged in the indictments?
Okay, so the judge asked the question, any evidence that is after, because this is a good question, because I was wondering if the state was going to bring in the deaths of Tylee, or that Lori's children went missing, and the deaths of Tylee and um JJ, and also Tammy, or I wasn't sure if any of that was going to come up, and the state's answer is going to be that there's not going to be anything after the indictment, but the judge asked, is there anything after the date of the crime? And the state is, their answer to me was clear, but I don't know if the judge, I don't know, because the judge's question and the state's answer was a little different. So I'm gonna go back to the judge's question.
In the case in chief, does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime of that have been charged in the indictments?
The state, although there is information that occurred after that that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process, is completely irrelevant and will not be brought in during the trial.
So the judge's question was, is there going to be anything after the date of the offense? And the state clarified there will be nothing brought in after the date of the indictment, which are two different dates. There are years in between those two dates. And so I do think, and the state said that they've already disclosed the information that they plan to bring in that occurred after, like in that in between time, which was probably used in the grand jury, to the grand jury as well. But
I didn't mean the date of crime of listed in the indictment. I meant the date of the indictment. So the state doesn't plan on
so the judge clarified, because that wasn't his first question. The judge clarified his question right there.
presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
All right. Are you otherwise on track for your trial date?
Correct.
Are there interviews going on with your investigator or your advisory council team?
We're working on getting those set up right now.
Okay. Is there anything else we need to address today? This was sort of just a status conference to make sure things are on track.
I have 2 motions that I'd like to file with the court today.
All right. Do you have copies for the state?
I don't today. I thought you could make a copy.
Can we see them?
Sure.
I'll ask the deputy county attorney, from your perspective, anything we need to discuss here today? Yeah.
No, Your Honor.
How long, I'm assuming the 2021 case would be the case that the state intends to try first.
Correct.
How long would that case take for the state's portion to present?
Probably a couple weeks, Your Honor. I mean, and I say that obviously I'm unaware of how long defense will take for cross-examination.
I think cross-examination is going to be long. I think it's probably going to take a month. I do not think cross-examination is going to be short. I could be wrong, but I'm thinking they should probably double the time just in case. I think it's gonna be long. Um, and, uh, uh please make sure if you ever do have a trial in your area and if you would like to be on a jury, make sure to not follow any of the coverage because if you follow coverage of the trial, you'll most likely be dismissed. um, uh, I know of a situation where somebody got a jury survey because they weren't summoned for jury duty yet, but they were sent the survey just to ask, do you have any extenuating circumstances where you wouldn't be able to be on a jury? Our area has a pretty public trial that will be starting, I think, this year. It's the Manassas Park trial. And so if people follow the news about cases, you'll most likely and just remember, I'm not a lawyer, okay? And then if you are called for jury duty, make sure to never follow any of the live coverage. Wait until after the trial is over to say anything because courts are monitoring chats. Courts are going to feeds to see what people, to make because and lawyers too. Lawyers because a lawyer wants to see if no. So Sarah, Dr. B's tips to make sure that trials are effective and that justice is served. Because one of the worst things to do is to have a juror like violate their, yeah, I don't know, like to is that's why you're always truthful on the survey when you're answering those questions. Alec Murdaugh might get a new trial but that's more because of Becky's stuff. And then Ashley Benefield, she's trying to get another trial because a juror didn't disclose a history of some DV charges or some experience with DV. So always make sure to answer the questions accurately. If you're not sure, ask. All right. It's a whole thing. Let's keep it going because they're now talking about how long this will all be.
So I would probably ask to pre-screen the jury for significantly longer than that.
Meaning 3 weeks or 4 weeks?
Yes, Your Honor. I obviously, I do not know what Ms. Daybell is going to question any of the witnesses.
As we're looking toward that trial date, is advisory council willing to assist the defendant on the jury screening process if we do the electronic questionnaire?
Yeah, to the
Okay.
extent that we're
All right, good.
going outside of our scope, but yes.
Sure. I have
So and the defense attorney, because I guess advisory council normally would not assist the defendant in the pre-screening process. I don't know, but she said that they'll do it if that's what they're being asked to do.
I've received a motion for specific discovery from the defendant, well, 2 separate ones. Just going forward, can you title them maybe what specifically you're looking for? Because if you name all your motions the same thing, it gets a little difficult to keep track of them. But I have 2 separate motions for specific discovery.
Just like discovery.
For example, on this one, you could title it something like motion for discovery related to the Gilbert DR number or something like that, just to differentiate these. We'll make copies of these for the prosecutor and then we'll have those filed with the clerk today. One of your requests was to have the state send you directly any pleadings, which according to their mailing certificate at the back of the pleadings, they are mailing them to you. I can't do anything about how long the jail takes to process that. So I do recognize that there's probably some delays on that, so we won't hold you to the normal reply times because of those delays that it takes getting through the jail administratively. All right.
In that case, Your Honor, could we have perhaps that go to my investigator, then I could maybe get those faster? Can he also be included on that?
Your Honor, I do email them to advisory council as well as in the court, so.
All right.
But there's not much else I can do.
Who's your investigator?
So the prosecution is letting Lori know that her advisory council is emailed on these. So let's keep it going.
Jeff White.
And your advisory counselor in contact with him? Yeah.
They can be.
Okay. So the record will reflect that the state's getting a copy of those two motions today, and then the state will respond accordingly. I'll just set a
Sorry for going a little slow.
I'll have you reply within 10 days of the date of the filing of their response. All right.
A bit faster.
Depending on and then I'll rule on the motions as they come, or I'll set a hearing if need be. But at this time, I'm going to affirm the final trial management conference of March 18 at 8:30 a.m. in this division. Trial date's currently March 31. Again, the first case that would be heading to trial would be the 2021 case. Anything else for today?
Yes, will trial be staying before Your Honor? And if so, will we be staying in this courtroom?
I don't know yet. I'm going to confer with the.
So this is just the logistics, but I think it's important for us to still hear and see these parts too.
Associate presiding judge, and I suspect it will stay here and it will stay in this courtroom, although for jury selection, we may move to a bigger courtroom if we're doing in-person board here.
And Judge, I do know there will likely be the next of kin present. This courtroom obviously does not have a victim room or a witness room. With the media, that obviously makes it more difficult for the state to keep those individuals away from each other, from overhearing each other in this type of case. So obviously, we're happy to stay before this court, but would be requesting that this be reset.
And that was interesting. I had never heard of a victim or like a family room. I had never heard of that. And I like the idea of that, where there could be a separate space where the family's able to review the trial and everything. So yeah.
Or move to the South Park Tower, so we would have those accommodations.
I'll talk to the criminal presiding judge and the associate presiding judge regarding that. And it's just a matter of availability of bigger courtrooms. Anything else from the defendant?
I just was going to ask, can we set both trial dates, or how are we going to do that?
You'll have two separate jury trials with two separate juries.
Correct.
So the first trial that will be on or around March 31st. We anticipate when that trial is done, we'll talk about how quickly we're going to do the second trial. Does that answer your question?
Somewhat, yes.
Okay. It's hard to set the second one without knowing how long the first one's going to take and then the readiness of everyone as far as the second one after the first one concludes. All right, we will be at recess on that matter. I'll take any motions under advisement.
So that was that. I'm going to check the chat. Let me know if y'all have any general questions. She's proceeding pro se. She's defending herself, but she does have advisory counsel because it's not like Sarah Boone, where Sarah Boone lost the right to have court-appointed counsel. Lori just requested to represent herself. And if at any point it gets to the point where either the judge feels that, because like if she's not listening to the judge, if it goes off the rails, I think the judge can order her counsel to come in. The judge went over that during that hearing. Please check out my Lori Vallow playlist if you wanted to see that hearing. But oh my gosh, it is And Nishay, this is gonna be a show. It's gonna be a lot. It's gonna be a lot. Um, okay, so Northwest, you think she wants the trials to be over and to go back to Idaho. And I think she's being housed in jail versus prison. Sometimes in prisons, you get like face to face visits, or sometimes prison, because person is there, they know they're going to be there for a longer period of time. Jail tends to be the open bay. I don't know, like, I think Sarah Boone liked jail better than prison because she was trying to stay in the holding to not be convicted of a crime, and that didn't work. Uh, but someone asked me to talk about the Morgan, is it, if it's Geyser, y'all know me and names. So let me share my screen right here. So, and I did a video because she has come before the court multiple times requesting release. And she is a teenager that was being held in a mental health facility due to a serious attack on someone that she called a friend. There is a video, Peyton, y'all know me in names. Lutner, sorry if I said that wrong, was 12 years old when she was 19 times by two friends. And the other individual was already released. So it was Morgan and one other individual. The other individual was already released, already got that conditional release. And it's my understanding that she had fulfilled all the requirements of the, like, that facility could no longer meet her needs. And someone asked me to talk about juveniles getting placed in psychiatric facilities, and we've seen juveniles get placed in prisons when they are convicted of a crime. And with this, um she was found not guilty by reason of insanity, and that was why or I don't know if the state agreed for her to plead not guilty by reason of insanity, but when you do that, the court and the mental health facility, everybody comes together to say, have you fulfilled your goals to be able to be discharged? And with a conditional release, she can be court ordered to treatment. She can be court ordered um to a facility, like to a lower level facility, to like a group home. And the facility where she was at was concerned that they didn't have the vocational and educational resources that would be helpful for her long term. And that's why I think the doctors at the facility were on board with her being discharged, because that testimony came out at her first hearing. I think out of 3 doctors, there was 1 doctor that wasn't sure if she was ready, because she was saying that she was never delusional, or that she doesn't have major mental health problems. And but they were concerned she was just saying that so that she could be discharged. And was she aware of her mental health? And could she comply with societal norms, expectations, all of those things? And so she will continue to be monitored. And this happens. Um, um, Oy. I think I think she was 12? I don't know. Like, she was young when this happened. And so, because all this information came out, she must have been charged. I don't know if she's in a state where she was charged as an adult. This was back in 2014. So I don't know all of the details of this, but it's a lot. So let me go on ahead and play that video, because from Court TV, I haven't seen Because I did not see her, I did not see this before. Full screen. Let's put it back to, okay, good. One time. Perfect. All right.
Good evening, Michael. Big news today. The judge granted the petition for Morgan Geyser's release. This was her third attempt at cutting her 40-year sentence to a mental health hospital short. The common theme of today was the unanimous support for her petition for conditional release across 3 doctors, including her court-appointed psychologist.
Unresponsive to treatment.
Correct. And again, that risk management part is a prediction of what she's likely to face, but her institutional stability, her acceptance of rules, her willingness to accept feedback, that all bodes well for her compliance with conditional release.
To be clear, your ultimate conclusion is that you are in support of her petition for conditional release.
Yes.
Geyser's last attempt at release was in April of last year. That request was ultimately denied by a judge. But her psychologist says since then, there were large improvements in the strength of Geyser's interpersonal skills and her responsiveness to treatment. Dr. Deborah Collins is another psychologist who was called by the defense. She did not support Geyser's release last April, but today she said there were new factors supporting her conditional release.
What are those protective factors and dynamic factors?
The protective factors include her intellectual resources and her capacity for problem solving. She has improved coping skills for managing stress that she has worked on and developed with the assistance of years of treatment and the treatment team she has at Winnebago. She has an demonstrated improved capacity for self-regulation, emotional self-regulation. So managing stress in the institution, decreased frequency by to use fantasy or to use, I guess I would say fantasy or retreat into herself for coping. And she also has an expressed motivation to proactively pursue a pro-social life course moving forward.
Both the state and defense presented conflicting closing arguments to the judge as well.
This was a brutal attempted murder. The effort to stab somebody 19 times. But then she's not dead, but then they leave. Of course, with the idea or thinking that she'll bleed to death. You know, when I think about this, Judge, I can't help but thinking most people in society are not capable of committing the offense that Morgan Geyser committed.
The question becomes whether they've shown by clear and convincing evidence that today, as you look at Ms. Geyser sitting here in court as an individual, whether she still presents that same risk today. She doesn't. She doesn't. Their own witness that they called explained why she doesn't.
Now, the judge asked for a proposed conditional release plan by February 14th to give the parties time to evaluate it. It's up to the judge to accept or reject that plan. It's also important to note the victim in this case, Peyton Leitner, survived that 2014 attack.
All right. And so, like I said, during the last hearing, only two of her treating providers were supportive of her release. One was not. And so it was almost a year. So I guess it was 8-9 months. So from April to January, improvements were made, and now all of her people are on board. My mom said, "What about the victim?" I don't, because I think the victim could have attended this hearing and made a statement. I did not watch the full hearing, so I'm not sure if a statement was submitted. all right. Can someone plead not guilty by reason of insanity and have the state accept that if they believe someone is insane? So I've covered a lot of NGRI cases here. Not every state has not guilty by reason of insanity as a possible defense. During Lori's first trial, that was not an option. And because of the state she was in, there are some states that have guilty but mentally ill. We just saw a case in Georgia. It was the Chloe Driver case. She was found guilty but mentally ill, and she pled not guilty by reason of insanity. And guilty but mentally ill, there is still a prison sentence with the not guilty by reason of insanity. So that is a plea, and the state doesn't have to just accept it. So the state has an expert that will evaluate the individual. If the Because even in the Chloe Driver case, the neutral state of Georgia expert felt that mental health played a role. The jury determined that she was not that she was guilty but mentally ill. It still went to the jury. It was a jury trial, and it still went to the jury. I think there are cases where the prosecution that maybe don't go all the way. I don't know, where they come to an agreement. There may be cases that don't go through the court process. There are definitely cases where the prosecution feels the person is guilty, and the defense puts forth a not guilty by reason of insanity, and then it's up to either the jury, or if it's a bench trial, it's up to the judge. Remember, I'm not the lawyer. I know a lot about the mental health stuff, and this is where mental health and psychology, or mental health and the law, intersect, and that's why I like talking about these cases. Um uh so Nashay, I do not know what Morgan's pronouns are. I think in this hearing they use she her pronouns. So I do not know. Okay. So somebody mentioned that one of the doctors explained, but I don't want to demonize things, cuz sometimes people use, if if when marginalized groups, when small groups, if something happens, and so there was recently a story of two gay men that have been charged with horrible crimes against their adopted sons. And that is any parent's worst nightmare. And there can also be a man that's married to a woman that does the same to adopted children. So I don't like to demonize sexuality or gender. Crimes are crimes, and people should not do crimes. So yeah. All right. Um, all right. Let me know if y'all have any last questions. I appreciate each and every one of you. I tried to stay caught up on these things. Nashay, this is, I think I have my trans flag, but like, so I have all I have all most of the flags. So the flags that came in a pack from Amazon. I try to create a safe space. I try to delete comments if I see them. Um, um, and then I also just try to give out information. But yeah. So, what advice would you give someone in Lori's counsel situation? So, Lori's counsel just has to support her, and Lori's going to be able to put forth the defense that she wants. And her counsel thought that she was competent to do this. They helped her. They filed the motion. Like her counsel helped her be able to do this. Now they probably advised against it. And during that hearing that we watched, where the judge was asking her questions like, is anybody pressuring you to do this? And Lori was like, no, quite the opposite. Like everybody's, and she didn't say this with her mouth, but I interpreted that to mean everybody is telling me to not do this. Like a person that represents themselves represents a fool. Like, do never, never, never represent yourself if you are, you know, yes. And so this not legal advice, just general information. Oh, you were the one that asked the question on Instagram. Thank you, thank you. Yes, yes, that's awesome. Um, uh, and so I'm worried if Kay, um, because that's yeah, I'm concerned about Lori cross-examining victims. Lori cross-examining police, the investigators or the experts. I'm not really concerned about that. My heart goes out to the victims. My heart goes out to if Colby is put on the witness list, if other family members are put on the witness list. I do need to take a look because I think her brother Adam Cox did an interview, or there's like a police recording of Adam Cox that came out that I haven't watched yet, and so I'm gonna have to watch that. And if there's something for us to chat about, I definitely will, because I think Adam might play a big role, and because Charles reached out to her brother Adam to say, I'm concerned about her. Um, Melanie Gibb, and I'm not worried about Melanie, like, but Kay and Colby, uh, uh, I'm just, uh, 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 but yeah, it's hard. It really is hard. Okay, yeah. So, and I haven't listened to that interview yet. Um, I don't know if they'll be able to ask Zalima some things because Alex, her husband, even though he died, I think there's still some spousal privilege. And there could be some things that Zalima knows, but anything she saw or heard, she could be asked to testify about. And as long as it's not something her husband told her, unless they go through a process to try to elicit that testimony. Um, ah, wow. Okay, so Sam R, I will have to try to find that interview because um I know that there is a podcast out there, and I have watched that podcast with them. Yeah, it seems like Adam got away from the family. Like, it seems like it's not, but, like, it seems like Adam is healthy, and, I really hope that they're all doing well. Um, okay, so but Zalima and Alex got married, though. So, during marriage. Oh, so were they not married? When all this happened, they might I don't know. I don't know. Y'all know me and dates. Nishay, I am glad that Colby is setting boundaries with Lori. I wish Colby and his family all the best. And he has supportive people in his corner. Um, I hope that this brings families closer together. Um, I don't think Lori would try, yeah, yeah, 'cause Chad's kids wouldn't have anything to do with any of this. I just wonder who Lori's gonna call and what defense Lori's gonna try to put forward. Like, is she going to is she gonna stick with it was self-defense? Is that gonna be that Alex was defending himself like this? Charles, professional baseball player, is no. I think if Charles was going after Alex with a bat, Alex would have had major injuries, I think. And so, yep, yep, yep. Ah, they were only married for a few weeks. Okay. Ay, okay. Thank you. Thank you. Y'all know I love following trials. This one has a lot. Hey, buddy. All right. Um if I think it's in my bag, okay? Yeah. If it's not in my bag, you'll have to wait for me to be done, okay? All right. If you all are in an area that's impacted by the fires, my thoughts go out to people in California. I hope everybody is safe. If you're in an area that was impacted by snow, I hope you stay warm. May your hot cocoa stay at the perfect temperature. And I will see y'all on Tuesday. I'm going to go play in the snow with the kiddo after he's done with the iPad for a little bit. Y'all have a good one. Bye.